Hi, everyone. Welcome to Litigation Trends in the COVID-19 Era. My name is Pam Abate Datillo. I'm one of the presenters today. I'm an attorney at Fredrikson Byron, obviously. I'm in the Employment and Labor Group, and then I'm also in our litigation group. And my practice is about 80% litigation and investigations, both employment and some non-employment as well. So looking forward to sharing with you today some of the research on litigation trends in the COVID-19 era, but then also sharing with you some of our own kind of more anecdotal experiences given what we've seen in the last 8 or 9 months. So before I have Brian and Lucas, my co-presenters, introduce themselves, I'm going to cover just a couple housekeeping items. So first of all, at the bottom of your screen, you'll see a toolbar with a variety of engagement tools. These tools are resizable and movable, so feel free to move them around to get the most out of your desktop space. If you have a question during the webinar, you are free to type it in the question and answer tool, which is at the bottom of the screen. We'll do our best to address questions at the end of the program. We'll try to leave some time for that. Under resources, you'll find a copy of today's slides and some additional materials relevant to the program. Live webcast attendees will receive a follow-up email after the webcast with continuing education details. If you are interested in a certificate of attendance, you can download one from the continuing education tool. And finally, we are recording today's program, and you'll receive an email notification when the on-demand version becomes available. If you run into any technical difficulties today, just try refreshing your screen by hitting F5. You can also click the help tool for answers to common questions. You can also just shoot us a question if you're having a technical issue, and we'll do our best to help you get straightened out. So with that, Brian, why don't you introduce yourself and then pass it to Lucas.
Thanks, Pam. Good afternoon, everybody. I'm Brian Morbin, also an attorney in Fredrikson Byron's Employment and Labor Group. I also practice primarily employment litigation with a side of compliance and advice and counseling. In the litigation areas, I do kind of the gamut from non-compete, business torts, a lot of single plaintiff, discrimination, retaliation, wage claims, some labor work, unfair labor practice charges, and a niche area of ERISA litigation as well. Lucas?
Hi, everyone. My name is Lucas Baining. I am a second-year associate out of Fredrikson and Byron. Work in the Employment and Labor Group, also work in the Business Litigation Group. Similar to Brian, a lot of my litigation runs the gamut from non-compete, wage and hour, all sorts of really fun stuff. And then I also assist on pressing advice needs that some of my partners request.
All right. With that, we'll get started. So I thought we would start with spending just a few minutes sharing with you what litigation actually looks like during the pandemic right now. It's probably not going to come as a huge surprise to any of you that the legal world, like the rest of the business world, has moved to a different way of doing business. We're doing a lot more online. We're doing a lot more remote. And while that's probably an obvious point in terms of what the world looks like right now, it has had and is starting to have really an impact on how these cases ultimately play out and how these cases ultimately settle or go to trial. So one of the first observations we wanted to share with you is that since the pandemic started, not at the beginning, more toward the end of spring now to the present, I'm seeing an increase in case filings, claims, and investigations. And it's interesting because we pulled some national statistics that actually show nationally employment lawsuit filings are down 12% in 2020 as compared to 2019. And they are reporting a fairly large reduction in harassment cases, because as you can imagine, people working remote, probably less likely to have those types of claims, and a decrease in discrimination and other employment cases. So those are the national statistics, but as always, court filings don't tell the full story, and often too what we see nationally doesn't always match what's happening here in Minnesota. So in Minnesota, my experience from both watching the daily dockets, where we get a report of every case that's been filed that day, plus our own experience handling these cases, I was quite surprised to see the national statistics, because we're definitely seeing an increase. And not all of those get filed, so that could be one reason for the discrepancy between what we're seeing and what's being reported. A lot of these are complaints that result in an investigation, not necessarily litigation, or it's too early yet to see whether it's going to result in litigation. So what's the reason for this? I've chalked it up to a few different things. First, there's movement in the labor market. And whenever there's a lot of movement in the labor market, there tends to be a lot of non-compete litigation, trade secret litigation. Those cases in particular, I've seen an uptick in the filings in Minnesota. There's also a lot more employee complaints, whistleblower concerns. Those are leading more often to charges of discrimination or retaliation as opposed to filings. But I've seen just a steady flow of those, mostly related to workplace safety or remote work or being required to come back to work. There's a heavy flow of those right now. And then finally, I also chalk it up to just a general discontent in the workplace right now. People are feeling, most people haven't had a vacation in a long time. Most people are not having as much meaningful time off, working long hours, and feeling less connected to your employer, feeling less of that loyalty people often have to their employer, because they're sitting in the living room looking at people via Zoom, or worse yet, not really interacting with people even via video. And so there just seems to be a discontent generally, often misunderstandings, jump to conclusions about what was intended by communications. And I think we have less of that when we interact in person than we do when communications are via chat and email. I think things are often taken out of context, and that's creating a lot of discontent. All right, so once there is a claim, once there is a charge, wanted to share just a couple thoughts on what litigation looks like right now. With a charge, there really isn't much difference in terms of the process for defending a charge, except, of course, if you decide to go to mediation to try to resolve the charge. Most mediations are being held remotely now, where everybody logs on, just like we're doing today, on our computer via Zoom, and the mediator has different rooms set up, and he or she moves from room to room. Every mediator I've worked with during the pandemic, which has been probably 5 or 6 of some of the top mediators in Minnesota for civil litigation, have all said they are seeing the exact same success rates. So whatever their success rate is, 90% of their mediations settle. They say that remote mediations have not changed that whatsoever. I find that very surprising, because my experience with remote mediations is that with really emotional cases or cases that are really contentious, I've not had the same success getting those cases settled at mediation. And I think the process, in my opinion, is not as good as an in-person process where people can really develop a rapport with the mediator. Also, when we do live in-person mediations, there is often, but not always, an opportunity for the parties to get together in the same room. And sometimes it's just the attorneys. But that piece of it doesn't have the same effect via Zoom. And sometimes it's a very effective tool to get a case settled at mediation. Depositions are also being done remote. Early on in the pandemic, we had some motion practice with the judge over whether someone had to show up for a mediation, or excuse me, for a deposition, because there is a school of thought that a deposition cannot be as effective over video. those motions unanimously went toward the party who wanted to do the depositions remote. So pretty much every deposition is remote right now unless everyone agrees to do it in person. And that has changed the dynamics of depositions quite a bit. You obviously can't see what else is going on in my room right now. I could have, somebody across the table from me holding up cue cards. It's the same thing in a deposition. If I'm taking the deposition, I don't know what's going on the other side of the room. It's also easier for witnesses to try to kind of squirm out of answering questions, and it's harder to get real direct answers to direct questions. So that's been a struggle for us. The good part of it is that we've been able to have our clients more engaged in the litigation process. So clients can log on and watch depositions just like you're watching a webinar, and that's been a really great change because it's allowed all participants to litigation, employer, employee, get more involved in the litigation process and see firsthand how the depositions unfold rather than hearing about it after the fact. And then just very quickly, court hearings, a lot of those are also going to Zoom. Civil trials are being postponed or delayed. Federal court right now is closed to civil jury trials until the 1st of 2021. State court jury trials are going forward, but they are very cumbersome. It's difficult to get jurors. There's lots of precautions that have to be taken. So in turn, there's a huge incentive for both sides to settle before trial because of the difficulties with trying a case during the pandemic. All right, so we're going to cover different types of cases today, different types of litigation that is trending either nationally or here that relates to COVID-19 in some way. So I'm going to cover the first set of cases, and I'll pass it to Brian and Lucas to talk about different subject areas. So what I'm going to touch on right now are the COVID-19 transmission cases. So what litigation are we seeing that directly results from someone getting COVID-19? So there's generally 3 types of cases that have been trending nationally. First is employment wrongful death cases. So if an employee receives a transmission of COVID at the workplace, so from another employee, and then the employee who contracts it ends up dying, we're seeing some wrongful death lawsuits against the employer. And I'll give a couple examples. Second type of case is customer wrongful death or just class actions over illness of a large group of people. And that has been largely coming out of the cruise ship industry, where customers who contracted COVID-19 during a cruise have either bonded together to file a class action, or it's been one isolated person suing the company for the exposure. And then the third type that is trending is nursing home wrongful death cases. So if a patient of a nursing home or assisted living facility dies from COVID-19, we're seeing lots of cases nationwide where the nursing home is being sued for wrongful death. All right, so I'm going to talk first about the employment ones. Probably the most well-known example, and the case that a lot of people are watching right now, is Evans versus Walmart. So Evans, Wando Evans was an employee of Walmart, and Wando died having contracted COVID-19. And while it remains to be seen whether it truly was contracted at work or somewhere else, for the lawsuit alleges it was contracted at work. And so the lawsuit is being brought by his relative. And the allegations are that Walmart is responsible for significant damages caused by the death of this individual because it didn't enforce social distancing rules, it didn't provide PPE, it didn't warn some employees that others had symptoms that were consistent with the COVID symptoms. And there's also an allegation that Walmart generally failed to adhere to OSHA and CDC guidelines. So this case is, people are watching this case because the relative has sued not just Walmart, the employer, but also the landlord who owned the building, which is kind of an interesting take. And his theory is that the landlord also failed to make sure there was a safe work environment. So typically, an employee, including their relatives, once the employee dies, cannot sue an employer for wrongful death or for contracting an illness in the workplace. Why? That's because every state has a workers' compensation system that requires any workplace injuries, including illnesses, to be handled solely and exclusively through workers' compensation. It's not that Mr. Evans' attorney isn't aware of that. He's alleging that these COVID cases fall into an exception, that the employer's conduct is so egregious here that it rises to the level of these very, very narrow exceptions that allow an employee to get out of the workers' compensation system and sue for millions of dollars in punitive damages in civil court. So there's a motion to dismiss pending right now. Walmart has asked the court to dismiss the case and order them to litigate this issue in workers' compensation and not expose Walmart to the additional penalties, damages, punitive damages that would be available in tort. And the court has not yet ruled on that case. So won't spend a lot of time on these two because it's really the same as the Walmart case. The only reason I bring this up is to share that it isn't just this Walmart case. This is sort of trending now nationally. We've got a similar case against Quality Sausage Company in Texas, and then a case against Smithfield Fresh Meats. In both of those cases, it's very similar, where the employee contracted COVID-19 at work and died, and now their relatives are bringing a lawsuit against the employer and making similar arguments to Walmart in that, the plaintiff in Walmart, the argument being, your conduct was so egregious, it fell so far below the CDC standards that you cannot shield yourself with the workers' compensation system. You are exposed now to a much bigger, more expensive lawsuit. Again, none of these cases have been decided yet. They're virtually all on motions to dismiss, with the employer asking the court to order it to workers' comp. I frankly would be surprised if any of these cases are allowed to move forward in court as opposed to workers' compensation, because the exceptions are just so narrow. In most states, it has to be where the employer engaged in gross misconduct or intended to kill the employee. I mean, it's just very hard to meet. But we're watching these cases, because if one falls and goes the other way, it's going to open up a whole line of litigation against employers in court for workplace illnesses. And I will say, too, that even if these employers win these cases, it's still an uncomfortable place to be needing to defend it, because the allegations are pretty damaging from a PR perspective. It's that these companies disseminated misinformation about COVID-19. They didn't enforce mask mandates that were required by governors. They didn't enforce social distancing. So I don't know if those things are true, but that's what's being alleged. And so it can also be a PR nightmare. All right, cruise line case. I'm kind of going over my time here, so I'm actually going to skip this, but it's the same concept. Customers suing employers when the customer believes they contracted COVID-19 at the employer's place of business. There is no safeguard of workers' compensation for cases like this. Customers obviously aren't covered by workers' compensation. And so there have been only a few of these cases so far, and really high profile type cases, but we're still watching them because, of course, it can have ramifications for smaller businesses as well. All right, then the nursing home cases. Very similar to the customer cases in the sense that the person, the plaintiff who is suing, there's no exclusivity of workers' compensation. So they can sue for the full range of damages in a civil lawsuit. So there's been quite a few lawsuits filed across the country against nursing homes, assisted living facilities, for not providing allegedly safe enough environments for their patients, for not following social distancing, for not making full disclosure to families and to patients about employees who had COVID-19 symptoms, And right now, all of these cases have not played out to the end either, because we haven't had enough time for them to get to the end to have a substantive decision. And really, there's been a lot of litigation over whether these belong in state court or federal court, a question that really interests only lawyers and judges, so I won't probably waste any time with that. But there's been tons of litigation about whether there's a federal preemption issue. So we haven't gotten really to the merits of these yet. So high level, and then I'm going to pass it off to Brian. These cases that I just shared with you, the transmission cases, I'll call them, they haven't played out to a conclusion, but there still are, as always, best practices we can glean from this trend of filings. And the best practices are, got to follow the governor's mandates. Seems obvious, but a lot of companies, even here in Minnesota, are not doing it. When they have a group of employees who say they're comfortable not wearing masks, for example. Also need to make sure that preparedness plans are in place and up to date. They should be continually monitored and updated as the health department puts out new guidance and prepares an updated plan. So updating plans, following the mandate, and making sure that education that's provided to employees is sound and is from the CDC or reputable source, obviously not using materials produced by a non-health official or government source. So with that, I'll pass it off to Brian to talk about specifically about some employment litigation we're seeing in Minnesota.
Thanks, Pam. That's awesome. For my section, I'm gonna, like as Pam said, I'll talk about some of the employment-related litigation that we're seeing more generally, and then I'm gonna focus on a specific section of discrimination, wrongful termination, workplace safety kind of claims, give you guys some examples of cases that we've seen and handled in that area, and then I'll give you guys some tips and best practices for how to avoid being one of those cases. So from a high-level perspective, what kind of cases are we seeing? They are kind of run all the gamut of normal cases that have existed. There's not a lot of new claims. They just have kind of a spin on the facts to bring them into COVID-19 related issues. Breach of contract, these kinds of cases include independent contractors or consultants that employers are no longer needing or don't have the money to continue paying. So those kind of contracts are getting breached. Those claims also extend beyond into, lease and landlord and tenant issues. There's lots of businesses downtown that have a lot of office space that are not being filled with employees right now. So they're trying to get out of leases, withholding rent, and we're seeing a lot of litigation in that area as well, although not super employment related. In the constitutional civil rights area, there's lots of claims challenging these state orders, the mask mandates, the business closures, and those kind of things. Lots of failure to pay claims are really prevalent right now, whether it's just regular wages, whether it's the emergency paid sick leave, just leave lawsuits in general under the FMLA and the expanded FMLA, misclassification suits. These include both the independent contractor employee misclassifications that are common, but also exempt versus non-exempt. We're seeing lots of non-compete litigation, as Pam mentioned, and then on the flip side, WARN-Act lawsuits are really spiking right now. When the business closure orders came out in this early spring, lots of companies were forced to lay off, terminate, or extendedly furlough employees, and that's created issues with was notice given timely, and we might see another spike in that right now as we're seeing more orders to reclose businesses. Workers' comp, whistleblower, workplace safety, in my mind, is probably the second biggest one right now, right behind the wrongful termination and discrimination claims. Employees want to keep their jobs and they're suing when they are getting fired under those areas, but when they are keeping their jobs, the next most important thing on their mind is probably workplace safety. I don't want to get infected. Am I going to get exposed? Is my employer doing a good enough job to keep me safe when I am at work? So some examples of these wrongful termination, discrimination, workplace safety cases that we're seeing. Here's a brand new one that was filed just a couple weeks ago in Florida federal court. And in this case, the plaintiff worked as an office clerk, and in the early spring when the pandemic hit, March, she fell ill and was admitted to the hospital, where a couple days later she tested positive for COVID-19 and was also diagnosed with pneumonia. While she was at the hospital, she was intubated for an extended period of time and then finally discharged in late April to continue her recovery at home. During her hospital stay, she alleges that she and her family kept her boss up to date on her condition, but nonetheless, the defendant terminated her employment while she was at the hospital and while she was intubated. So she sues the defendant under the Emergency Paid Sick Leave Act for failure to pay 2 weeks of leave while she was unable to work because of her diagnosis, and then also under the FLSA for retaliation against her for needing leave to recover from that diagnosis. She also packaged in a non-COVID-19 related overtime claim under the FLSA. Obviously, at this point, we have no idea how this is going to shake out. The employer hasn't even answered the complaint yet, so we don't know if these allegations are completely meritless or the employer might have had completely justifiable reasons for terminating her. We don't know. But I wanted to raise this case because I think it's an interesting one, and it's an interesting reminder to be mindful of the potential narrative of the story that an employee may tell in a future complaint when you are making these decisions to lay off employees and terminate employees. Again, the employer might be completely in the right here, but as Pam mentioned, from a PR standpoint, there's allegations in a publicly filed complaint now that you fired your employee while she was intubated in the hospital, and that just doesn't look good. And it creates it puts the employer on the defensive right away. So it gets hard to climb back out of that hole when you're defending that kind of thing. In the second one I have here, this is actually a case that I handle for a client. We got a pre-litigation demand letter in which the plaintiff worked as a manager at one of several locations for the employer. When COVID-19 hit, they reevaluated and decided to consolidate their leadership and operations team, and as a result of that, decided to furlough and then later terminate 2 of the 4 managers. So the plaintiff, which is one of the ones managers terminated, she alleged that the employer discriminated against her and retaliated against her and the other manager based on their age and disability, because the 2 managers that were terminated were much older and disabled, or allegedly disabled, whereas the 2 managers that were kept were much younger and not disabled. She also packaged in some claims that she had requested to work from home in order to prevent exposing her significant other who had a disability and higher risk for complications, and the employer discriminated against her for making that request and due to her association with someone with a disability. And then finally, she alleged that they retaliated and discriminated and fired her in order to avoid their obligation of paying her emergency paid sick leave under the FLSA. And in this case, the employer had absolutely legitimate reasons, non-discriminatory, non-retaliatory reasons for selecting her and the other manager for the layoff, primarily of which was their objectively poor performance than the other 2 managers. And there was sufficient and well-reasoned documented evidence that and reviews and such that they were the worst of the 4. And that's why the employer chose them. But despite solid defenses to these claims, we don't know how these are turning out. And so we received quite a bit of pressure from the EPL insurer in this to put a little bit more money than we might have otherwise have done, given the uncertain nature of these kind of claims. So again, despite the solid defenses, these claims are still settling. People are still putting a little bit more money to avoid that uncertainty and risk and the headaches of litigation. But it's also a good reminder to be sure to document your decisions well and support them by good objective evidence of your legitimate business reasons, because from a 30,000-foot level, when you fire your 2 older managers and keep your 2 younger ones, that's an easy way for an employee to bring a claim. And then in the workplace safety realm, I went on the OSHA website just last night, and they have some data on there. So according to them, there's been over 10,000 federal OSHA complaints filed since the beginning of the pandemic, and more than triple that at the state level. So this is a very heavy area right now. And again, these aren't kind of complaints with the administrative agencies aren't showing up in federal dockets and state dockets as actual complaints. So they're probably not included in those numbers that's showing less litigation right now. And I also included another case here, Palmer versus Amazon. I thought it was very interesting because this is one of the few cases we've seen come out with an actual order and ruling on the claims at issue. So what happened in this case is that some workers in various roles at a New York Amazon warehouse, they filed a lawsuit back in June seeking a court order that making Amazon do a better job of protecting its workers from COVID-19, including giving them more time to complete their tasks and immediate access to paid time off that they hadn't accrued yet. And so some of the allegations in this case were that Amazon tracked employees' productivity in a way that if they were, away at the bathroom or taking a drink or whatever the case may be, they're getting docked for these times. And so employees were saying, hey, people aren't washing their hands. They're not taking the time to sanitize their workstation because they're fearful of being docked in this productivity time. And Amazon obviously disputed that claim, but nonetheless brought a motion to dismiss. And what the court ruled on they brought a public nuisance claim is what they did for the workplace issues, as well as a breach of duty to provide a safe workplace under New York labor law. And the court dismissed those 2 claims and said that OSHA has primary jurisdiction over these kind of claims. And so the judge's quote was that the workers' demands for greater protection turn on factual issues requiring both technical and policy expertise, including how Amazon's policies impact COVID-19 transmission and whether its rules are up to state and federal standards. These are questions better left for OSHA versus the court. And so that has more broader implication because this public nuisance is something that employees have been trying in other areas of the country as well. And the court kicked that out, saying, no, these belong with the agency. OSHA is better equipped to handle them. But it was also interesting because the court further ruled that, hey, even if I did keep this case, the public nuisance claim still fails because that kind of a claim requires a special injury beyond that which is suffered by the community at large. So such as, a noxious landfill, a malarial pond, a smelly pigsty, something like that. In contrast, the risks associated with COVID-19 are, quote, common to the New York City community at large. So there's nothing unique about the Amazon warehouse that's exposing the public at large to a greater exposure, a greater increase of in being infected by COVID-19. And then as Pam kind of hinted, the court also dismissed the breach of duty claim, or suggested it would dismiss that claim because if it was for a past injury, it would be preempted by the workers' comp law, and there's no cognizable claim for a threat of future injury under that law. And then finally, the failure to pay COVID-19 leave in a timely fashion. What the allegation there was under the New York law, state law. They had a duty to pay that leave within the next paycheck, and Amazon hadn't done that. And the court dismissed that claim, saying that COVID-19 leave is basically a form of sick leave, and under our laws, those are not considered wages subject to this state law. So it was really interesting to see how that one shaped up, and it very well could have broader implications, especially with respect to the public nuisance, the workplace safety issues, that those should be handled by OSHA, and there may not be valid claims there, even if the courts did consider them. So some general tips in these areas. So again, in the wrongful termination discrimination, the claims that we're seeing most prevalent are age and disability. And there's some research showing that older workers over 65 and older are about 2.5 times to be likely to be unemployed now than they were at the peak of the Great Recession. And some experts are attributing that at least partly to more age discrimination by employers. And why is that? I frankly think, from what I've seen, employers are not discriminating based on age and disability, but that's not to say that isn't happening. Are employers thinking older disabled workers are more susceptible to the virus? They impose more of a liability if they were to catch it. At least some plaintiffs' attorneys are arguing that employers are using this as cover to push these higher paid older workers out and replace them with younger, cheaper labor. So that's at least some of the allegations that we're seeing in this. So when you are making decisions to, these difficult decisions to reduce or lay off staff, consider what criteria you're using to make those decisions, and make sure that you're documenting those decisions well, so that you have a good paper trail to come back to if an employer, or if an employee rather, asserts that you terminated them because of their age. Simply citing economic reasons for getting rid of somebody at this time is not going to be enough. Be prepared to demonstrate legitimate reasons supported by objective measures that you can. So whether it's tenure or sales and billable numbers or job function, and also be aware of the potential disparate impact those decisions have on legally protected groups. So even if you're using objective measures such as job tenure, you don't want to do that in a way that may have a negative impact or disparate impact on individuals in protected classes, whether it be race or age. And then finally, consider offering a severance payment in exchange for a release in order to help avoid potential exposure and liability down the road. On the flip side, in addition, or in contrary to active, discrimination, some employers can mistakenly discriminate, even with the best of intentions. So, some employers that we've seen have been genuinely concerned about the health and the well-being of their workforce and their older and disabled workers, more specifically. However, the EEOC has given us some guidance that you're free to provide greater flexibility to this demographic, but you cannot exclude them from the workplace solely because of their age or disability. So if you're bringing younger individuals back and saying, no, Bob Smith, we want you to work from home, given your situation or your condition, that's a sure way to get a potential claim brought against you. In the failure to accommodate, I think this is interesting because there is a unique dichotomy here. Under the ADA, an employer has an obligation to provide a reasonable accommodation to an individual with a disability. However, if you have an individual who says, my significant other, or I have someone at home who has a disability, can I get an accommodation to help care for them or to avoid exposing them? The ADA does not require an accommodation in that situation, but it is illegal to discriminate or retaliate against them based on that association. So you don't have to provide an accommodation for someone they're associated with, only the disability of the employee, but you still can't discriminate or retaliate against them because of that. Looking at teleworking or remote accommodations into the future here post-pandemic, will they be required going forward? Again, we've gotten guidance from the EEOC that these kind of accommodations are not automatic under the law. An employer is entitled to understand, the disability-related limitation that necessitates the accommodation. If there is no disability requiring them to telework, then no accommodation is necessary. You do not have to provide an accommodation based on their age. There's no accommodation requirement in the ADEA. But if there is a disability-related limitation, then the employer is entitled to, effectively understand what is the limitation, and can we address that with another form of a reasonable accommodation at the workplace? If so, the employer can choose that alternative to teleworking. These are fact-specific determinations, and so they need to be resolved on a case-by-case basis. But as a practical matter, I think both plaintiffs and defense side attorneys would probably agree that it will be, you will have a tougher time justifying a decision not to allow employees to work from home, especially if it's just something temporarily going forward. So there have good data to support that justification if you choose to deny it. Finally, in the workplace safety realm, I'll just touch on this really briefly. Make sure you're providing adequate PPE if necessary, training to how to don and doff that PPE if necessary. Make sure you have good cleaning, sanitization efforts, social distancing, face covering protocols, and if you're in Minnesota, have a preparedness plan in place, because we run across some that do not, and that can be a big no-no. Make sure you are staying up to date and continually monitoring the federal, state, and local health and safety guidelines and regulations. Consider other proactive steps as, appointing a safety committee or a safety officer who can be responsible for monitoring developments, establishing, updating policies, training employees on safety issues, and the like. With that, I'll turn it over to Lucas.
Thanks, Brian. I'm going to talk about wage and hour and failure to pay cases that we've seen, and some trends that we've noticed in those two realms. And then I'm also going to talk a little bit about cases outside of the employment realm as well. So on this wage and hour and failure to pay, unsurprisingly, there has been plenty of these sorts of claims. So by one estimation, through the first 3 quarters of 2020, there have been about 309 COVID-19 related cases just on federal courts and federal dockets. And 129 of those, so that's just short of half, involve the Fair Labor Standards Act. And so that's the wage and hour statute. And this is because, we have a lot of layoffs, a lot of out of work employees. It's like the perfect storm for plaintiffs' litigation in a lot of ways. And actually, Pam and I were on the other side of a case for a Minnesota Fair Labor Standards Act with a well-known plaintiff's attorney early on in the pandemic, actually probably right around when unemployment numbers were skyrocketing. And we just had a casual conversation, and I asked him how business was for him during the pandemic and how his practice was. And you could tell from his voice that he was exhausted both mentally and physically, because he has more people calling him, not just because they think they have a claim, but because they hope that they have a claim, because they're out of work and in desperate situations. And so this might sound alarming or scary to employers out there, but as bad as it is, it can also lead to quick resolutions. And that, I think, was the situation that we had. Being in a challenging financial situation means that plaintiff might be willing to settle quickly for less than normal, based on the pure fact that they have bills and might be out of work. While we're on this topic, so many of you, I hope, don't need to see this slide, but given the economic situation that we find ourselves in, it's important to remember what exactly can happen if we aren't paying employees on time, particularly when they've been terminated due to COVID reasons or reasons related to the economic downturn. And so, for example, I'm going to talk about Mondello v. Kelco Construction. It's a New York case. Basically had a manager at a car restoration and customization garage that was complaining about the health and sanitary situation based on, a fear of contracting COVID. The supervisor dismissed the concerns, told him to leave it alone, used really colorful language in his communications with this manager. And then lo and behold, a couple employees contracted COVID. And so this manager requested to work remotely. And he also provided a note from his doctor saying he's got a high risk of contracting COVID. Well, his employer denied the request, but sent him home anyways. And allegedly, this is in the complaint, failed to pay him for at least 2 days of work for that week, just 2 days. Following Monday, the manager emailed him, told him to come to work, and basically said, show up or you're fired. I think he also said, bring a doctor's note that you can come into work, and then also waive all legal liability. But setting those facts aside, plaintiff did not show up and he was terminated. So he sued for damages. He said disability discrimination, retaliation. And then the kicker is he brought in unpaid wages and commissions under New York's labor law. And this is important because under this law, under the New York labor law, he could potentially collect 100% of his damages in liquidated damages, interest on those unpaid wages, and then attorney's fees and legal costs. So just these 2 days could lead to 100K. So things to consider, under the right circumstances, in the right state, vacation pay, bonuses, commission, severance, some of these could be considered wages that are owed upon termination. So make sure you're paying attention to what your obligations are. Pay your employees now or risk having to pay much more later down the line. Next, I'm going to talk about failure to pay for sick time. And so by now, I hope we all know that federal statutes do require employers to pay up to 80 hours of paid sick time for certain COVID-19 reasons. And as Pam will discuss, I think in a bit, this requirement, the law that had this in place, actually expires at the end of the year. But if you know that, you're doing better than a lot of the companies that we're seeing on the docket sheet. Just this morning, I did a count of just the federal cases, and there were 68 where the claim was at its core a failure to pay for leave that is mandated by the statute. And so due to the situation and the prominence in which this legislation was passed, a lot of these claims have, as Brian was kind of talking about, really compelling stories for the plaintiff side, a PR nightmare for the employer's side, really challenging to save face in front of a judge or jury. Examples include, I had to stay home to take care of a sick child, so they fired me to dissuade others from exercising their rights. I mean, that sounds pretty bad. They fired me because I was having a hard time breathing during a meeting and then asked for sick leave. I mean, that's really bad. They fired me because I complained that I did not think we should be working at the office or facility, and then I actually got sick with COVID and needed time off. So these are really, really compelling. If you're just sitting down that first complaint and reading it, really compelling stuff for the plaintiff's side, and that's tough to dig out of those holes. And I just want to note that one thing that I'm noticing is that it's not, sure, a lot of them are, I got COVID and needed to take leave, or I needed to help take care of somebody, I needed leave and they said no, so I'm suing under that. But these claims can often be, I think the expression is the camel's nose in the tent, something along those lines. They get bundled with a bunch of other claims. They'll go to an attorney, they'll explain the situation, and the attorney will think, well, are you classified as exempt? Or are you non-exempt? What is your working situation? They have a list of questions that they're going to ask. And so frequently these claims will also include retaliation, discrimination, wage and hour claims, and misclassification claims. So this Maria Duran is a good example. She sued originally for alleged failure to provide sick leave. They terminated, and for terminating her in retaliation, and then completely unrelated also alleged, I was required to perform off the clock work and I didn't receive overtime pay. So now you've got that claim coming in as well, and so that's gonna balloon that litigation. All right, next, we're running a little tight on time, so I'm going to be really brief on this one. There was a big question, particularly early on whether or not you have to pay employees for COVID-19 screening. There's really been no court opinion on the matter, so I'm just going to defer and say, if you have questions on this, contact an attorney to kind of assess your situation. It tends to be a case-by-case situation, and there's cases supporting having to pay, and there's cases supporting not having to pay. But we actually haven't seen that much litigation on this specifically, but give it a few years, and I'm sure someone will put together a class action. Next, I'm going to talk a little bit about kind of the exempt and non-exempt. And I think this is an area where we're sort of anticipating a growth in litigation, particularly with remote working. But first, I'm just going to note one of the cases I saw is the employer expressly converted people to exempt to avoid paying overtime. And just don't do that. That's not a good idea. That's going to lead to big problems. On the remote working side, so this, with people working from home, many of us can and do take our work home with us more frequently, whatever that actually means in terms of you're always working from home. But for non-exempt employees, they may feel pressure to continue working, or their supervisor hours or their hours might be skewed so that requests come in later in the evening or at off hours. And so this presents unique challenges. As you know, under the FLSA, employers have to pay for all work, including work that is not requested but suffered or permitted. And so there's issues with the remote work as to whether it was requested, whether it was permitted, whether or not they were doing it after hours or above and beyond. And one example, there was a paralegal who sued her law firm for working from home and not getting paid her overtime wages. And that's largely because she was working from home off hours, doing things, and they didn't have a good time system. So there's two takeaways there is use a solid time tracking tool, be in regular communication with your own employees. And I guess the last one is that even lawyers struggle with some of these things and aren't really sure how to handle it best. And so last, I just want to touch briefly on some of the non-employment related issues and cases that we've seen. A huge one has been dealing with canceled events, canceled orders, breach of contracts by not being able to fulfill. And all of this is largely due to COVID, economic downturns, an inability to perform certain contracts, canceling contracts with vendors. And so with that, the advice there is if you find yourself in this situation, always read the contract and see what the language is if you can make an amendment to the agreement, review the terms for cancellation or termination clause, because you really want to be able to present to a judge that you did try to work this out. Lastly, if all else fails, we've seen a couple businesses try to use the force majeure clause. And with that, that's like an act of God didn't allow you to perform this contract. And so there's no liability there. You really have to look at the specific language in the clause, because courts historically have construed these narrowly. And so specific language, obviously the closer you get to infectious disease or pandemic or COVID-19, those would be really good. Act of God may or may not get you there. And then there's also impossibility or frustration of purpose, but those are really challenging ones as well. And we're hoping to see some court opinions on those as well. The other one I just want to briefly mention is that we've seen, I think there's been over 1,200 cases nationally filed regarding business interruption lawsuits against insurers. This isn't an area that I practice in, but it's huge. And from what we've seen and what I saw in the trends is that nearly 75% of the cases have resulted in dismissals of the policyholder's claims. So the insurers are doing quite well with early motions to dismiss. There's been a few more favorable rulings lately for businesses filing those claims as strategies shift, but the lion's share has been not that successful. So now I'm going to turn it back to Pam.
Thanks, Lucas. With our last 6 minutes here, I'm going to try to look in the crystal ball and predict what kind of litigation we expect to see in the next 6 to 12 months. Vaccination policies. My crystal ball tells me that this is going to be a huge source of litigation in the next year. And what I mean by that is the latest information from The federal government is that the vaccine will likely, COVID-19 vaccine will likely be made available to the public in April 2021. So if that's the case, I think both healthcare employers and non-healthcare employers are going to be presented with the decision that they will have to make about whether or not to require vaccines among employees, and separate from that, whether to have different sets of requirements for employees who do choose to get the vaccine and those who do not. So, for example, one thing that I have heard some commentary on is that some employers may choose to have employees work from home exclusively if they choose not to get the vaccine. But if you get the vaccine, then you can come to work. So there are lots of challenging legal issues that this brings. There are currently, under the current legal regime, there are employers who have vaccine policies, mandatory vaccine policies, but they are largely healthcare providers. I have not yet seen ever a non-healthcare provider who has a mandatory vaccine policy for its employees, but some healthcare companies already do. For healthcare companies that currently have vaccine policies, they have to recognize certain exceptions that exist under the law. So under Title VII, there's a religious belief exemption. Under the ADA, there might be a reasonable accommodation that has to be provided to someone who doesn't want to receive a vaccine for medical reasons or disability reasons. And there are various state laws that may add additional regulations. So my crystal ball tells me that when the vaccine becomes available, this is not going to be an issue that only affects healthcare employers. I think that employers who are non-healthcare employers are going to be either one, wanting themselves to implement this policy, or two, receiving pressure from government officials, from the health department to make it mandatory to increase public participation. So whether that's a good idea or bad idea, I'm not going to comment on that, except to say that I am seeing a lot of litigation in our future surrounding vaccination policies in the private employment sector. Remote work accommodations. This is already a big source of litigation. This is not going to change. It is only going to increase with time. And so that our crystal ball tells us this is going to be under the ADA. It's going to be continuation of leave law litigation. And it may also tie into my first bullet point about vaccination policies. You know, how is that going to interplay with remote work accommodations if there are employees who object to getting a vaccine for religious reasons, for medical reasons, or just personal belief reasons? How does that impact the remote work environment? I think we'll see a lot of litigation around that. We're also predicting that there will be litigation regarding the FFCRA. The Families First Act expires at the end of December, so a month and a half from now. And as is, I think Congress has been a little busy or distracted with other items because they have not yet picked up what is going to happen with the FFCRA. So right now we have a situation where Families First leave is ending at the end of December. Schools are shutting down, requiring the need for parents to take leave to deal with distance learning. And so there will need to be something on the federal level, some extension of the Families First Act or a brand new law. And as with the first Families First leave, that is bound to bring litigation along with it. Cybersecurity, there's some statistics out there that are extremely alarming right now. I've heard things along the lines of there's been a 2,000 increase in cybersecurity attacks since COVID because of the remote work and the fact that systems are more vulnerable now. Myself, I've never had a client go through a cybersecurity attack, maybe one in the last 7 years. I've had two in the last couple weeks say that they were the victim. And as they described it, it was very similar, the two attacks, in how it happened and what was communicated. And so it made me suspicious that it's related, it's the same group. So now would be an excellent time to reevaluate cybersecurity insurance, cybersecurity policies, the safety of your network, get an outside audit, because cybersecurity attacks are really blowing up. And you can do a simple Google search to find some pretty alarming stuff out there that has started since COVID. Or not started, increased since COVID. Trade secrets, non-compete litigation, that's going to continue as this kind of discontent in the workplace seems to continue the longer we are all working remote and less connected to our places of employment. And then finally, I didn't put this one on the slide, but I would also say I've been reading a lot about PPP loan investigations and litigation. I've been reading that we need to be concerned in the next 6 months or so about the federal government investigating companies who received a loan and shouldn't have received one, or committed fraud, or didn't comply with the terms of the forgiveness piece. And so I think we can expect investigations and litigation surrounding PPP loans. So in conclusion, share 3 things, which may sound very obvious, but it's the truth. 3 things that I think help keep employers out of litigation, or if you end up in litigation, give you the best possible defense. First, Brian hit the nail on the head when he said somebody at the company needs to be designated with staying up to speed on federal, state, and local guidance on COVID. That's understanding the state mandates that are coming out from governors. It's understanding the CDC guidance. It's making sure that preparedness plan is updated. Many people implemented a preparedness plan in Minnesota and then didn't give it another thought. Well, then the department came out with a list of industry-specific plans that you have to have on top of the regular plan. So someone needs to be keeping up with these developments. Someone needs to be tasked with that at the company. Second is documentation. This is probably the most obvious thing, yet it's so common that we get into litigation or responding to a charge and we don't have good documentation. And especially with COVID-19, you need to be able to explain with good simultaneous documentation. What did you do? What was your policy and why? I'm encouraging employers to save in a file, what did you rely on at that time to make that decision? So what guidance were you relying on? What, print it from the CDC website, print it from the Board of Dentistry website, collect that information that justifies why you had that policy when you did it. When you require employees to come back to work because they can't perform the job effectively at home, why? Simultaneous documentation. What were the failures during the remote work period that you felt compelled to call them back to the office to work in person? And then the third thing I would say is more of one of these social touchy-feely things, but engage your employees. Discontent employees leads to lawsuits. And so I think we all, our law firm included, need to be trying to figure out, how do we engage people? How do we make sure people still feel valued? How do we make sure we're getting input from people? How do we make sure we're still connecting with the human beings who work for our company? Because it is the discontent generally that we're seeing in the workplace that is often the driver of a lawsuit. So with that, I think there was one question we didn't get to, and one of us will, looks like Brian actually answered the question. So we're out of time, but if anyone had a question they weren't able to get in to the Q&A, you can always reach out to one of us. Thank you so much.